My name is Joseph Blocher. I teach constitutional law and property here at the law school. I've met you before. I also write a lot on Second Amendment issues, which means that I am especially glad to be welcoming our speaker today. Let me first just say thank you to the Program in Public Law, which is sponsoring this event, and to Neil Siegel, who couldn't be here today but helped to organize it. And a very, very special thanks to Alla Lefkowitz for coming back to the law school to give us this talk. She's a 2010 graduate of the law school, went to work for Skadden in New York after graduation, and then joined the Brady Center, where she is currently a staff attorney. She has been involved in what I think of as not only some of the biggest issues in Second Amendment litigation, but some of the sort of cutting edge and most interesting issues in gun litigation. And she's going to talk about sort of both sides of that coin. On the Second Amendment side, she's been involved in defending regulations on assault weapons bans, for example, or assault weapons restrictions, including a big case called Highland Park we just talked about this morning. But she's also been involved in affirmative litigation, which is a really important area in the gun law and policy field that doesn't always necessarily get the attention it deserves. And by affirmative litigation, I mean lawsuits against laws that are, in some respects, if you think about it, pro-gun, I guess, if to use a somewhat simplistic approach. She's going to talk all those things through, and then we're going to leave some time for questions. So please do have some questions ready, and please join me in thanking and welcoming Alla.
Thank you so much for having me, and I'm very excited to be back here. As was just said, I graduated in 2010, went to work for a law firm for 3 years, and then went to work at the Brady Center to Prevent Gun Violence, where I've been working for the past 3 years. Guns in the courts it's a very controversial issue. People have very strong feelings about it. I'm going to do my best to give you both sides of the coin, to be as objective as I possibly can, and please don't, I'm going to use some phrases like assault weapons or gun control or gun rights. Please don't read anything into that. They're just the shortest way I could talk about things. So we have a pretty simple agenda for today. We're going to spend about 20 minutes on constitutional law, 20 minutes on tort litigation, and then we're going to try to leave 20 minutes for questions. If you all are not going to have any questions, I'm sure we could fill up those 20 minutes with many other things. And though it might not be expected, our constitutional 20 minutes or so are going to focus both on the Second Amendment and the First Amendment. There's a lot of kind of hot new topics being litigated right now on the intersection of First Amendment rights and Second Amendment rights. And then we're going to be spending 20 minutes on tort litigation, and that is primarily what I do, which is represent victims of gun violence in negligent sale or distribution cases, against sellers, against manufacturers, against the newest one, I guess, would be against websites. Yeah, let's get started. So you can't really start any discussion about constitutional Second Amendment law without discussing District of Columbia v. Heller, which was issued by the Supreme Court in 2008. It was the first time that SCOTUS held that there is an individual right to bear arms under the Second Amendment. It was a very tight decision, 5-4, written by Justice Scalia, of course. And then, sorry, I say that of course because it's something I should know without looking down at my notes, not because. So, I mean, I think the two most important things that should be taken away from DC v. Heller are, one, it was the first time that individual right was recognized by the Supreme Court. And the second thing that should be known about it is it left a lot more questions unanswered than answered. And we could talk about why that was. It was a very close decision, so there's some possibility that there just couldn't be there wasn't a lot of agreement on anything else other than this very central issue of an existence of an individual right. But the court was very careful to say that, like most rights, the right secured by the Second Amendment is not unlimited. And then we're going to go into some recent decisions which address this very topic right here. And the core holding in DC v. Heller, which is whatever else it leads to the future evaluation, the Second Amendment elevates above all other interests the rights of law-abiding, responsible citizen to use arms in defense of hearth and home. Law-abiding, responsible self-defense in the home. Those were the core holdings of DC v. Heller. But it didn't decide a lot of other questions, like what is the proper level of scrutiny? What kind of tests do we decide if there has been a Second Amendment violation? Does it apply outside the home? Because the law here was only applied to a ban inside the home. And once DC v. Heller came down, it really spawned a wave of litigation since then on all sorts of topics, which we'll touch on. Interestingly, only one case has gone up to the Supreme Court since 2008 that discussed the Second Amendment, and that was Mcdonald v. Chicago, which held that that the Second Amendment right applies to the states as well. And since then, the Supreme Court has taken great pains to not take Second Amendment cases. They've taken quite a few gun cases, but even when, most recently, for example, even when a gun case had a Second Amendment question in it, the Supreme Court has specifically rejected this, taking the Second Amendment question and has taken just a statutory interpretation question. So no case since 2010. I personally think that's likely to change soon, but we can also debate that as well. Assault weapon bans. This is one of the most hotly debated recent types of litigation that has gone on since the Heller decision. And it was after the Sandy Hook tragedy, the Aurora tragedy, and any other number of mass shootings that I could name here, a number of states passed restrictions on whether private individuals could keep assault weapons. And that's defined in a number of ways, but essentially, can you fire a gun, can you fire more than 10 bullets without having to change your magazine? The assault weapon restrictions also frequently had restrictions on high-capacity magazines. So what does Heller tell us about whether assault weapon bans are constitutional or not? Heller says, the Second Amendment right is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. On one hand, you would think that supports the constitutionality of assault weapon bans. On the other hand, it says the types of weapons that are protected are those in common use at the time. And common use at the time has been interpreted to mean now, not at the time of when the Second Amendment was passed. But there have been historical limitations on dangerous and unusual weapons. So, can I go back? Oh, okay, great. One of the key questions becomes, well, assault weapon regulations do in some way regulate the core of the Second Amendment right in the fact that they could regulate law-abiding, responsible citizens' right to keep arms within the homes. But are assault weapons the types of weapons that have been found to be dangerous and unusual, and are they in fact in common use? I don't know. I don't have the statistics off the top of my head, but millions of people own assault weapons. I think that has become important to the courts. However, I'm going to ignore Colby v. O'Malley for right now, but every single court that has looked at states like New York, Connecticut, D.C., and Illinois that have Highland Park that have passed assault weapon regulations have upheld these regulations and said they're perfectly fine. The one circuit that disagreed with that was the Fourth Circuit in Colby v. O'Malley, but as with a lot of these cases, the circuit court is usually not the last stop. Colby v. O'Malley was just argued in front of the en banc Fourth Circuit, and we'll see how that turns out. The original circuit held that assault weapons restrictions should be subject to strict scrutiny, which was the first time that had been held with regard to assault weapons. And we'll see what the en banc decision holds, but that's definitely one option that may be going up to that depends on how things work out, may go up to the Supreme Court. I should say in the Seventh Circuit, this is a case that I was involved in. It was a township called, I want to make sure I'm not over time, Highland Park. That case was litigated all the way up to the Supreme Court. The Supreme Court refused to take cert in that case, but it did. Two justices, I think Thomas and Alito? And Alito dissented from the denial of cert, saying, no, the Seventh Circuit wasn't really following Heller, and we should really be taking these cases. Let's see. So, there are two key questions that come out of assault weapon litigation. One is, under what level of scrutiny should these bans be, or restrictions should be evaluated? Under strict scrutiny, under intermediate scrutiny, under something altogether? And another question that I particularly think is very interesting for me is, can a constitutional right be based on market share? The idea is, the plaintiffs in these cases say, well, a lot of people own assault weapons. But a lot of people, one could argue, own assault weapons because those are the weapons that are being marketed by the gun industry. So if the gun industry chooses to market another type of weapon, will that then acquire a Second Amendment right? On the other hand, if guns that, for example, if you start developing guns that have smart guns, for example, they are not commonly held at the time. Does that mean smart guns are not protected by the Second Amendment? So I think it's an open question. I think it's very interesting, and it has not been decided as of yet. The second question, the second kind of hot topic, in my opinion, probably the hottest topic in Second Amendment litigation is public carry. Heller dealt with a ban on firearms inside the home. It specifically avoided, let me see if this is the next thing I say. No. Okay, well, I'll leave that up. It specifically avoided touching on, is there a Second Amendment right outside the home? Can anyone carry firearms outside the home? And it has not been decided yet. There have been only one circuit, the Seventh Circuit in Moore v. Madigan in 2012, Judge Posner recognized that there is a right outside to carry outside the home, and he held that, well, you're just as likely, if not more so, to be attacked or to face danger outside the home than you are in the privacy of your home. Of course, on the other hand, you have the argument that may be true, but when you take a gun outside into a public street like Chicago or New York or Washington, D.C., by having a gun, you're potentially endangering a lot more people. Whereas in your home, if you choose to defend your home with a gun, the only people you're endangering is yourself, and you've chosen to have that gun. So that's the kind of the key issue there. Interestingly, Moore v. Madigan kind of became not super relevant because as of right now, there is no state, not one state has a complete ban on carrying firearms outside the home. 0 out of 50 states. Every single state allows some type of carry outside the home. And that becomes the question. And then we start dealing with open carry versus concealed carry. Most states, I don't have the numbers on me, quite a few states allow open carry, which is having a firearm where people on your person so that people could see. A lot of other states have concealed carry regimes, which means you're carrying a firearm, underneath your jacket, in your pocket, whatever the most appropriate means for you is. Quite a few states now have a rule that says only certain people with good reason can carry firearms outside the home, and that may be because you've been threatened, you're being stalked, you carry a lot, you work for a bank and you carry a lot of money. The important thing here is Heller held that most courts for a long time recognized that restrictions on concealed carry were perfectly lawful under the Second Amendment, and most circuits have upheld concealed carry regimes, including the Second, the Fourth, the First, and the Ninth. The interesting thing about these cases is in the Ninth Circuit, California has essentially, for the most part, outlawed open carry. And they have said, okay, we're allowing concealed carry for certain people that have good cause, and they have to apply for a permit, and not everyone can have concealed carry. And so this is a case called Peru v. Gore. It just came down a few months ago, I think. And it held, it doesn't matter we're not here to decide the question of, is there a right to carry outside the home? We're only here to decide the question of, is there a right to concealed carry outside the home? And Heller told us there isn't, so that's all we're dealing with. And so immediately thereafter, a gun rights plaintiff filed a lawsuit saying, okay, forget concealed carry. The case is called Flanagan v. Harris, and it's saying, but is there a right to open carry? And that's kind of teeing up the discussion of, is there, in fact, a right to carry outside the home? The two cases that are pending right now is DC has a fairly restrictive concealed carry permitting scheme, and that was just, and essentially the plaintiffs argued it's too restrictive, and you don't. If I just want to protect myself outside the home, that should be good reason enough to be able to carry firearms outside the home. DC, on the other hand, argues, and I guess it's kind of skipped an important part, is the danger and the reason that a lot of jurisdictions have outlawed concealed carry unless you have good reason is because it really poses a problem to police officers. Once a lot of people... Sorry. How many minutes are we in? 20? I feel like... All right. But the reason that a lot of jurisdictions have enacted concealed carry regimes, restrictive ones, is because when police officers are interacting with people on the street, the more guns that are concealed, they have to assume that people are carrying firearms. And I think, we could touch on that later, but clearly interacts with other problems that are going on right now. So DC argued this is having too many people carrying guns endangers our police officers and endangers everyone because we don't know who has a gun. We have to assume that everyone might be carrying a gun. And so that was just argued in front of the DC circuit yesterday, Tuesday. So we'll see. And even though most courts have upheld the concealed carry laws, the DC circuit did seem pretty negative on DC's laws, so that's definitely, I wouldn't be surprised by a decision striking that law down, and then we'll see if that's something that is going to head up to the Supreme Court. As applied challenges, this is the third and last Second Amendment category kind of hot topic that I wanted to touch on today, and it basically, something important. So I haven't touched on the Gun Control Act at all, but the Gun Control Act was passed in 1968. It's the main federal law that basically says there are 9 categories of individuals that are not allowed to carry firearms. It's own, possess, carry, buy, whatever firearms. Felons, people convicted domestic violence misdemeanors, people who have been involuntarily adjudicated as mentally ill, involuntarily committed, and so forth. So these lawsuits challenge the Gun Control Act prohibitions as they apply to the plaintiff. And the key thing here is that Heller said, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill. So I just want to touch on 2 cases that literally came down. I think Binderup came down September 7th. Tyler came down September 15th. So the one thing you should know about Tyler and Binderup, both incredibly fractured opinions, both en banc decisions. Binderup v. Attorney General, I think that decision was ultimately considered to be 8-7. Tyler v. Hillsdale, I can't even count what the number is because it literally had 8 different opinions. And I think tellingly, and I'll go into these cases a little bit more, but both decisions had a separate section in it that said, so you guys probably don't understand what we mean after we issued this case because it's so fractured. So here's what we think this case means. It was incredibly confusing. I mean, I think the Binderup decision is 174 pages. Tyler is maybe 80 pages, so a little bit better. But basically, I'm going to start with Tyler. Clifford Tyler was a man who 30 years ago was involuntarily committed to a mental hospital after he went through a very painful divorce, and there was evidence that he was going to injure himself. So he was committed in the early 1980s when it was a lot easier to involuntarily commit people. It's almost impossible now. And since then, the complaint shows that he has not had any mental health issues whatsoever. He has been perfectly law-abiding, and he wants to own a gun. So the Gun Control Act does restrict him, and because from owning a gun, and because he lives in Michigan, which does not allow people to rehabilitate their Second Amendment rights based on a mental health disability, he has no way of owning a firearm unless period. He has no way of owning a firearm. So in that case, it's obviously a very sympathetic case, as you could see. In that case, the majority opinion held that the United States had not shown that the restriction on people who have been involuntarily committed in the 30 years ago was substantially related to the important concern of the government from the danger to others, and very importantly with the mental health prohibition, the danger that one poses to oneself. Because it's been shown, and this is something that the Brady Center included an amicus on, that suicide with firearms is a lot more likely to actually be fatal, and people who have attempted to commit suicide in the past are statistically a lot more likely to attempt to commit suicide in the future. So that's one of and a similar decision in Binderup v. Attorney General. Those were we're at 1 o'clock. Okay. Those were two men who were convicted of. There's a prohibition on felons owning firearms, but what the prohibition actually says is anyone convicted of a crime that can be subject to a penalty for more than imprisonment for more than 1 year. However, Binderup and Suarez, it was a joint decision, were convicted of misdemeanor offenses that were punishable by more than 2 years, which would fall into the prohibiting category. And there, the court, to some extent, basically said their crimes were not serious enough, not violent enough. We're not really sure, but the government has not met its burden of proof to say that the prohibition does not violate their Second Amendment right. So these are two cases, and I think I have a quote from Tyler v. Hillsdale, which explains why I think this is the kind of case that may go up to the Supreme Court if they're appealed by the government. Tyler says, since 2008, the lower courts have struggled to delineate the boundaries of the right recognized by the Supreme Court in District of Columbia v. Heller. And these two cases, with their really fractured opinions, very difficult questions, I think present a fertile opportunity for decision by the Supreme Court. So that's what we're going to touch on right now for Second Amendment cases. I did want to touch on a couple of cases that were one of them was just decided also 2 to 3 days ago, and the other one has not been yet decided. And this is, both cases involve actually First Amendment rights. Defense Distributed v. U.S. Department of State. Defense Distributed is a company that manufactures blueprints for 3D guns that can be manufactured, and they post them online. And then the key thing about printable 3D guns is that if you go through security with them, for example, at an airport, they won't be caught by a metal detector. So Defense Distributed publishes these blueprints for how to make 3D guns and post them online. There's a federal law basically that says you can't do that. And Defense Distributed challenged that law and said, this is a restriction on our First Amendment right. This is a prior constraint on our First Amendment right. The Fifth Circuit just issued an opinion 2-1, again very fractured, that said that may be so. That this might be an infringement on your First Amendment right, but there are national security concerns with terrorists, so forth, with people outside the United States getting these blueprints for how to make these guns and bringing them into the United States. So the national security concerns there trump the First Amendment concerns. Then we have another case. This is actually a Brady case. I'm not personally involved in it, but it's something that we've been working on for a while. It's come to be colloquially known as Docs v. Glocks, because I still don't know how to pronounce that first name, and this is technically our client. So Florida a few years ago passed a law under this anecdotal idea that doctors were discriminating against patients that had guns in the home. That apparently doctors were saying, no, if you have guns, I'm not going to treat you. There's a lot of dispute whether that is actually the case. So they passed a law that basically said that doctors are not allowed to ask patients about whether they or not they have guns in the home or guns accessible unless it's directly relevant to the treatment. I don't know if there was a Comedy Central clip on this case. It's very funny. I highly recommend it. But so if someone has, a bullet wound, obviously you could talk to that person about guns. But what pediatricians have really started doing is when you come into their office, they'll start asking, Are there things in your home that could potentially endanger your child? You know, do you wall off your swimming pool? Do your kids have helmets? And one of the questions that doctors have started asking is, do you have firearms in the home? Because firearms have statistically been shown to endanger children in the home. And so doctors were worried, if we start asking these questions, are we going to lose our license? This is one of the most interesting things I've personally ever seen. The 11th Circuit issued an opinion about a year ago, maybe a year and a half ago, saying, no, this is not a First Amendment violation. This is perfectly fine. There has been a showing that maybe doctors are discriminating against people who own guns. So we're fine with this law. Then we issued we asked for en banc review. Then the 11th Circuit said, again 2-1, said, no, it's fine. It doesn't violate the First Amendment for this, and this reason. And there was one dissent. Then we once again asked for en banc review of that decision. And then the 11th Circuit once again issued a third opinion on the same case, rewriting its analysis each time, being like, no, this really doesn't violate the First Amendment. It's my personal favorite. The dissent in that third case essentially said, I've already written 2 dissents to this case. I'm not writing a dissent again. It was like 2 lines, like it's the same reason stand, I dissent. So that case was just argued before the full 11th Circuit en banc, and we'll see what happens. So those are our constitutional cases. So, and now we still have about a half an hour, is that right? Great. I wanted to talk to you about cases that maybe you are not as familiar with. This is something that I do every day. I just came from Kansas City on one of our cases. These are lawsuits brought by gun violence victims against members of the gun industry for purported wrongs, whether they be negligence, negligent sale, negligent distribution, creating a public nuisance, a public defect. And you may or may not have heard a little bit about these kind of lawsuits because it came to be kind of a hot topic in the Democratic primaries. There's a federal law called the Protection of Lawful Commerce in Arms Act, which has come to be known as the Federal Immunity Law, and we'll talk about that a little bit. And Democratic candidate Hillary Clinton voted against PLACA, and Bernie Sanders voted for it. So it was like one of their main distinguishing factors, and it was hotly debated. Lawsuit, right? So it's basically lawsuits for negligent sale or distribution practices, product defect, or creation of public nuisance. So I'll just touch on one of my cases, and then I'll give you more details. I have a client who, and this is all alleged, purported, because this is an ongoing case. My client is a mother who called a gun store, essentially begging the gun store to not sell a firearm to her adult daughter. The adult daughter had been diagnosed for many years as a paranoid schizophrenic. She had been in and out of hospitals, had multiple involuntary commitments for only a short period of time. For a short period of time, and had really been kind of cycling in and out of serious mental health issues, serious danger to herself. So this woman went to a gun store in May of 2012, bought a firearm, and may or may not have tried to commit suicide with the firearm. Her parents took it away and thought that was fine, and they were trying to get her mental health treatment. We were trying to make appointments with doctors to get her admitted to a hospital, call the ATF, call the FBI, a whole bunch of things. And then on June 25th, less than a month later, the mother, my client, was very concerned that her daughter was about to get her Social Security check because she was receiving Social Security benefits for her paranoid schizophrenia because she couldn't work. So she called the gun store, and according to her testimony, she said, my daughter came into your store before. She bought a gun. She's a danger to herself. She has paranoid schizophrenia. She's been in and out of hospitals. I'm begging you as a mother, please don't sell her a gun. That's all. Here's her date of birth. Here's her Social Security number. Here's what she looks like. Here's her name. Please don't sell her a gun if she comes in. So 2 days later, and this is a very small gun store, total of 2 employees, so we're not talking about like a Walmart or something. 2 days later, her daughter walks in attempting to buy a firearm, and the same person who took the phone call was the same person who interacted with her. He, of course, sold her the gun. Otherwise, there wouldn't be a case here. He sold her the gun. Within an hour, she went home and she killed her father. So this is the kind of cases we're talking about. I think the Brady Center has about 10 cases such as this. But I mean, can anyone think of a claim that that person would have against the gun store? Any tort claim that you could possibly think that a plaintiff would have against the gun store in that case? Go ahead. Okay, so negligence would be the first thing that you would think of. That's good, and that's right. Anything else? Well, that should be right. Let me rephrase. Anything else? Go ahead.
Wrongful endangerment?
Wrong. Yeah. Right. Okay. I would say that relates to negligence. Well, okay. So yes, I think that's right. There's a duty not to cause harm to others. The allegation would be that the gun store breached that duty. So this is when we come to the immunity laws. The Protection of Lawful Commerce in Arms Act was passed in 2005. And basically what it said was no gun violence victim can file a civil lawsuit against any member of the gun industry. That if the injury to the plaintiff resulted due to a criminal or unlawful misuse of the firearm. Essentially, if someone shoots someone, you can't sue the gun industry. Either defendants, manufacturers, sellers, trade associations. There are a couple of exceptions. The exceptions that are relevant here are negligent entrustment and a knowing violation of firearm law. There is no exception in the federal immunity law for negligence. And courts have consistently held, though I might disagree as an attorney, but courts have consistently held that you cannot bring an ordinary negligence claim against a gun dealer. So we were no longer allowed to bring that claim. And we did go up all the way to the Supreme Court of Missouri in that case, and they said, no, you can't bring that claim because of PLACA. So the only thing that was really left for us in that case is negligent entrustment. Negligent entrustment is when you give someone something, when you have reason to know that person may cause is too dangerous to have that thing. Most classically, negligent entrustment has been used, for example, if parents let their drunk kids use their car. That's a classic negligent entrustment case. So you're thinking, that's fine, we could just go win this case on negligent entrustment. No, because Missouri, like many states, doesn't recognize a negligent entrustment claim for when it pertains to a seller. So if I loan you a gun, I can be held, and I know you're a felon, I can be held liable for negligent entrustment. If I sell you the gun, I cannot be liable for selling you that gun, which, as you could see, doesn't make a lot of sense in the fact that you've now pretty much created incentive for people to make money off of negligent entrustment. So we did go up to the Supreme Court of Missouri on that question, and they did overturn the law. There had been multiple Court of Appeals cases, decisions in that case, and they did overturn that law, and they said, no, actually, you can. We're going to say that you can't have a negligent entrustment claim against the gun dealer. And so we're going to trial, end of January. Keep an eye out for it. We'll see how it goes. All right. So state immunity laws. The thing about PLACA is it has exceptions. There are many states, and I don't have the exact number on me, that have purported to that have enacted what they claim or what defendants claim to be state immunity laws with no exceptions whatsoever. Period. You can't sue a gun seller if someone used the gun to shoot someone. We have a case that was just argued in front of the Indiana Supreme Court. And this is very similar to many of our cases. I'll just back up for a second. Very common way to get guns illegally is to use a straw purchaser. Does that sound Basically, you come to the store with someone, and you have someone else fill out the transaction form. The background check is done on that person, and you leave the person who's not allowed to have the gun leaves the store with a gun. I mean, it's happened over and over and over again. It's classic. It's something that gun stores should be and are taught to be looking out for. Our client in that case was an Indianapolis police officer who was chasing a suspect. The suspect got out of his car, shot the police officer, injured him, thank God, and the police officer returned fire. We filed a lawsuit on behalf of the police officer saying that this gun had been sold in an illegal straw purchase, and that the gun store should have known that this was an illegal straw purchase for a variety of reasons, including the fact that I won't bore you with those, but let's assume for right now that the store had good reason to know that this was an illegal straw purchase. The defendants in that case are claiming, at the motion to dismiss stage, are claiming it doesn't matter if we did anything illegal. It completely doesn't matter. Under Indiana law, if we sell a gun illegally, if someone walks into the store and says, I'm a felon, but I want to buy a gun, can you sell it to me without a background check? And they're like, okay. Then once that gun is used in a crime, the gun store can no longer be sued. There's complete civil immunity. So that was just argued up to the Supreme Court of Indiana. It doesn't, with the question of, doesn't matter what you do, has Indiana in fact made that policy decision to never hold members of the gun industry liable even if they do something wrong? And I don't want to predict on that because that's one of our cases, but I recommend, the case is called KSNE v. Runnels. It's up online, the arguments, and there are very interesting discussions on that law. And I think we're wrapping up, and maybe questions. I did want to touch on just one other thing with regard to PLACA. You know, there's kind of one of the conversations that I've had in debates and that I've seen on TV is, well, it's not so bad because it does have a few exceptions. PLACA was passed in 2005. Until 2015, there had not been one case that had gone to trial against a gun dealer or a member of the gun industry. 10 years without one case going to trial because of PLACA. PLACA was retroactive, so any cases that had already been filed before PLACA was passed were thrown out of court for the majority. And then essentially for 10 years, we, primarily the Brady Center, spent trying to get a case past the motion to dismiss because of PLACA. Finally, in 2015, we had two cases go to trial, one in Juneau, Alaska, and one in Milwaukee, Wisconsin. The facts, and this is going to be very quick, but the facts of the Alaska case were essentially a man wearing a garbage bag who happened to be a fugitive, which is a prohibited category, walked into a gun store wearing the garbage bag, asked to look at some guns, and found a gun to look at. And then, all we know, because the video amazingly didn't work, which is something that we hear a lot from defendants, the video doesn't work that day, the person, that fugitive left the store with a gun. He left the store with a gun and left $200 on the table, which was the purchase price of the gun. Then immediately thereafter went out and killed a young man randomly who was just out on the street. That case was, you couldn't have a negligence. So the argument there is that it doesn't really matter whether you agreed or whether you just, the defendant was saying, oh, I left the gun on the counter and I turned my back. I had no idea that he took it. That's a negligence case. So we didn't have it. So we had to prove without the evidence of a videotape that there had been an agreement between the two men there to actually sell the gun without a background check. We ended up losing that case. So the only other case that has gone to trial was in Milwaukee on behalf of two police officers. That was a case that I was involved in, who were both shot in the head by someone that they stopped. These are young guys, both in their 20s, both have permanent injuries, one to his brain, one to his face. An illegal straw purchase that was caught on camera by a gun dealer that had been ranked to be the #1 seller of crime guns for many years in a row. I should say was an affiliate of that other gun store. And we did have a video in that case, and we were able to prove that that was an illegal straw purchase, and we're able to say that that was negligent entrustment and a knowing violation of law, and the plaintiffs were awarded $5.7 million in that case. That was the first case to go to trial since the passage, to get a verdict since the passage of PLACA over 10 years ago. So yeah, that's it.
That's wonderful, Alla. Thank you so much. That was a tour de force because that covered really just an amazing amount of Second Amendment doctrine and some of the really pressing and interesting cases. And I know we'll have a lot of questions. I'm going to use moderator's privilege and just jump myself to the front of the queue.
This water is mine?
It's yours.
Okay, great.
Arm yourself with it. So one question that I always have when I think about whether the Supreme Court's going to take another case, which is an issue Alla and I were talking about this morning, is was brought back to me when you were talking about Highland Park and the dissent from denial of cert there. And I should just emphasize for any of you who aren't close court watchers, it's pretty remarkable for justices to issue a published dissent from denial of cert. Usually the court just doesn't take a case and that's the end of it. But there have been a few cases now, and Highland Park is one, where a combination of, it's only ever been Justice Thomas and Justice Scalia. Highland Park came out just after Justice Scalia had died, and Thomas and Alito instead of Thomas and Scalia. But really saying we need to take another case. One of the themes in that opinion, and that I hear a lot from, for lack of a better word, gun rights lawyers, is the sort of the frame that they're trying to convince people of is that the Second Amendment is being treated as a second-class right, and that what the problem here, and you see this, I think, in the Highland Park dissent, is, look, the lower courts are not enforcing enough, not strongly enough what we said in Heller. They're not treating this as a fundamental right. And I wonder if you think that's true. And the reason that I ask this is because a lot of the cases you were going through there were, and this is true, cases where the Second Amendment claim fails. And just numerically, the vast majority of Second Amendment challenges after Heller have failed. It's something like 90% of 1,000 cases filed. Is that good evidence, actually, that Scalia, Alito, and Thomas were right that the Second Amendment is being treated as second-class right?
I don't think so. Heller, and we didn't get into the whole discussion of Heller, but Heller did specifically go into, it made a very big deal of the fact that we are emphasizing that the Second Amendment right is not unlimited. That there are all sorts of presumptive regulations against guns in schools, certain people who can't own firearms, about concealed carry that are presumptively lawful. Once the Supreme Court acknowledges that a whole bunch of laws restricting gun ownership and gun possession are presumptively lawful, then I don't think you could be treating every single Second Amendment claim under a heightened scrutiny, strict scrutiny. So I don't think that's right. And I think there's one case out of the 10th Circuit that says it best, and it says Second Amendment rights, it's not that they're different, but we have to understand the danger that emanates from people having firearms. So that does make the Second Amendment right a little bit different, that in the fact that once people have firearms, that endangers other people. It may also provide the owner with self-defense, but it also endangers other people. So in that way, it distinguishes the Second Amendment rights from other rights. And I think that's hugely important.
Absolutely. So happy to take questions from the floor. I'll call people. Alla and I could talk up here for hours and hours and hours, but I'm sure folks have some reactions, questions, comments, objections.
Please object to anything I said. I'm very happy about that.
Let me ask another one while people get their courage up.
Sure.
So you've been at Brady Center now for 3 years, and Brady, as you guys probably know, is sort of has been the biggest organization, biggest, most involved organization on the, for lack of a better word, the gun regulation side for decades now. But in recent years, it seems to me, the sort of political institutional arena has changed. It's been populated now by sort of new groups. Is that changing the debate in a way that maybe is useful?
You mean other GVP groups?
Every town, responsible gun solutions, et cetera.
I think it's fantastic. From my point of view, and this is, clearly I do work for the Brady Center, so I do have certain ideological views that are not on an academic front. There are at least 3 other organizations now that are nationwide. We work closely together in that the fact that we make sure that we're not over, if one organization is doing something really well, then we'll let that organization do it really well. One of the things that Brady has, in my opinion, done really well is the affirmative litigation. We're really the only group that does that, and the other groups are very respectful of that. And I will call up the Brennan Center, or I'll call up every town, and I'll say, "Hey, I need help with this case," and they just talk me through it, and they talk me through it. So I think it's fantastic. A lot more resources all over the country, and I think it makes things kind of a more fair playing field.
But one thing that I'm curious about it is why it's being handled under the First Amendment framework. I understand that was probably a decision on their part rather than on the court's part. But the second question I had regarding that is they tried to make it free online. Had they distributed it in a different way, like via CD, for example, where they would have to make contractual purchase agreements, would it still be illegal, or would it be treated more as a gun sale, which would grant them some immunity?
So you successfully asked me a question about the one case I know least about. So thank you. So I don't know why it was when on First Amendment grounds versus Second Amendment grounds. Has been recognized that there can be all sorts of regulations on the commercial sale of firearms, whether that's 3D or non 3D. So that perhaps is the reason why they went First Amendment. The important thing is the immunity law, the federal immunity law only applies to federal firearms licensees. So they're regulated by the ATF. You have to have a license to sell, manufacture, import firearms. I don't think I could be wrong. I'm not sure that they don't. Okay, so the immunity law wouldn't apply to them. Yeah.
Fascinating.
Was the shift from talking about the Second Amendment as defense against the government and more a shift towards individual citizens' right of self-defense in sort of personal life? Do you think that is a permanent shift that we've seen, and how does that shift impact your work in terms of the types of firearms that are being litigated and what you think the chances of success are?
Sorry, you mean as a
shift from that sort of anti-tyranny, freedom from government, Second Amendment account to the self-defense against criminals account, which the hell are?
Well, I think that's a very helpful shift to, and again, I'm using these, I hate these labels, I don't believe in them, I just want to make that very clear. I don't assign anything when you say gun control, gun rights, I don't care about that. I think that's a very helpful shift for the gun rights movement to frame it in terms of you're taking away our rights, this is our right to self-defense. It becomes much harder, and I think the important part is that in these constitutional cases, we're always the defendants, not the Brady Center most of the time, but states and federal government that passes it are always the defendants. So it's always much harder to present your view of what the law is when you're the defendant, because the plaintiff gets to choose their case, right? They get to take a case like Tyler, which is a very sympathetic plaintiff, and they choose to bring that, and that may or may not go up to the Supreme Court. So I think it's a very helpful shift for the gun rights movement. I would say, so my boss, the director of the Brady Center, is issuing just wrote an article called "The Right Not to Be Shot," and I think that's pretty straightforward, and the recognition of the right to life. And I think that is, it's trying to balance, right? Yes, there's a right to self-defense, but there's also a right for people who don't want to have firearms to live. And I actually, just to touch on that very quickly, one of the more interesting cases we had was when a township in Georgia passed a law that said everyone had to have a gun. So every head of household was required to own a firearm. And, the argument there, and it ended up settling because they realized probably wouldn't work well for them. The argument there was, to the extent the Second Amendment right recognizes an individual right to choose to have a firearm. It also recognizes an individual right to choose to not have a firearm. So.
How much of an effect have gun lobbies or specific groups, or maybe like relationships those gun lobbies have with senators or other officials through organizations like ALEC? How much of an impact have they had that you've seen in this area of like litigation or in
What's ALEC?
the American Legislative Executive Council? So basically, they form relationships between senators and lobby groups.
Well, from my personal point of view, I would say a very strong effect. It's interesting because these gun cases, there are immunity laws all over the country. State immunity laws, there's the federal immunity law. Those are passed, obviously, by lobby, those are pushed by lobbyists for the gun industry, whether or not you disagree or not, but it's just a fact that's why these laws are passed. And they're all over the country. They're obviously on a federal level. And the idea is that, well, we could, from the gun lobby point of view, that we can trust and we can control legislators and what they do. We can't control judges. So I do think has been a lot of evidence that that it does have a huge effect. Living in Washington, D.C., I obviously know a lot of people who work for legislators who consistently vote against universal background checks, but doesn't mean they necessarily believe that, but they do consistently vote against them, sorry.
Add one thing onto that. It's a great question. I mean, I think one of the ways in which again, just to use the labels, although they're not entirely accurate, the gun regulation movement was outflanked by the gun rights movement for decades, was that groups like the NRA were very, very, very concerted efforts, smart efforts, and successful efforts, especially at the state and local level, to pass what can only be described as pro-gun legislation. So, I mean, at the federal level, PLCAA is a great example of this. But for me, I mean, the one that always jumps out is preemption. So the vast majority of states now have laws which preempt, meaning basically forbid, or at least strongly limit local gun control. And frankly, the local level is almost the only place now you can summon the political will to pass stringent gun control anyway. So cities that are in states where the legislature is controlled by, let's say, rural areas or whatever, which tend to be more pro-gun, are now just disabled from passing, or at least limited in the kind of gun laws they can pass. Those laws didn't even start going on the books till the mid-'80s, really. It was after Morton Grove's handgun ban. And it wasn't ALEC then, but that's the same basic idea of, like, here's a model template law. And it shows to me why I think Alla's work is so interesting is, like, this is not like a libertarian versus non-libertarian issue. Like, the law is intervening on both sides, like both against guns, if you like, and also for them. So it's not like I'm against regulation, therefore I'm pro-gun or whatever. Well, no. The pendulum is swung in some directions. That's the state is intervening on behalf of, frankly, guns and gun owners.
I think that's a really great point. And, PLACA, the federal immunity law, is a great example of that. In some way, it's supported traditionally by conservatives, right? Again, general label. But it is a federal law taking away the right from states to determine their own tort laws. Tort law has always been a state right. It's recognized as one of the core state rights, the idea that you could regulate interaction between your citizens and your state. The federal law takes that right away from the states. So it doesn't matter what you think. It doesn't matter that you recognize negligence. It doesn't matter that you recognize public nuisance. You, state judge, no longer have the right to do that. That's generally considered an overstep of federal power, but yet it is supported by more conservative legislators.
I have two questions. The first one's a dumb joke question. Aren't all guns 3D guns? Just call them 3D. But I was curious if you could comment more on the open carry versus closed carry police reactions, and talk about kind of like the policies that they're developing and kind of like the arguments that they have for the kind of public interactions that they then take into the streets.
Yeah, so that's a great question, and the concern from police officers' point of view, and that becomes the concern from the city's point of view and the state's point of view, is that once you have more firearms on the street, you endanger more people, right? Because the idea, especially when they're concealed, because at least when they're open carry, people could see that you're having a gun. They could choose to stay away from you. Or a police officer who's interacting with you knows that you have a firearm, right? When a firearm is concealed, it accidentally goes off. The person approaching you doesn't know if you have a gun. So from the police officer's generally point of view is that they now have to assume that everyone has a gun, if the more guns there are. So when they're automatically interacting with people, and I hope no one's taking this as a political comment right now, but this is the concern with the concealed carry laws, is that they now are being forced to assume that a person is, if they have any kind of action toward their body, that they have a firearm, and then they become more aggressive for that reason. So that's the concern. That's the general concerns from police officer point of view.
We sneak in one last quick question? In that case, let me close with a comment and sort of an invitation to everybody, because a lot of the questions actually that have come up and a lot of things that Alla talked about are things that are frankly open questions in gun law and policy, and I think indicate that this is a field where there's just more stuff to do and think about than in most other areas, frankly, of public law. And partly that's because Heller essentially created a new constitutional right in 2008. There are open questions in Second Amendment law like what is the standard of review, which are just unimaginable in any other area of law. So if you are interested in writing about, thinking about the Second Amendment, gun law, and policy, now is a great time. I was just jotting down the number of notes I supervised in recent years that address some of these issues, including one that DLJ published last year on the Dox v. Glocks case, which was a real headache for the student because they kept withdrawing the opinion and reissuing it. But there's a lot of stuff out there that you can do. You can actually have a big impact. And, I mean, frankly, Alla's career is testament to that. I mean, you are at the front lines of some really important cases now. 2010 grad, that's pretty awesome. The lawyering here is constitutional. You can do affirmative litigation, kind of as Alla's doing. But I encourage you, if you're interested in the subject matter, if you're just interested in doing really cutting-edge, interesting lawyering, find a way to get involved. And one way to do that would be probably to reach out to Alla. But certainly, whether or not you do that, join me in thanking her for coming.